The members of A, B, C, D, and E knocked at the door of the house of W. W was an overseas Filipino worker who just arrived in the Philippines from Japan. And one time, he went to the POEA to follow up something. Here comes A, B, and C. A, B, and C knock at the door of the house of W, asking for W, but W was not there. And it was only the sister Y who was there. And so, Y asked from A, B, and C, what do you need from my sister W? A, B, C said that we are employees, officers of the POEA, Philippine Overseas Employment, and we just have some questions for your sister. Would you allow us to enter inside and wait inside? And the said sister, yes, said that of course you can wait inside because they are officers of the POEA. And so they were allowed inside. Once inside, the said sister was about to take food for these visitors, but suddenly, these visitors held her hand and then thereafter tied her. Then here comes other men, and these other men ransacked the house and took all valuables from inside the house. Thereafter, they left. What crime or crimes had been committed by these men? There were two cases filed. Two cases filed. One is robbery by force upon claims. Under Article 299, First Act. They were able to gain entry by disguising themselves as public officers. So it is a form of unlawful entry. And another one is simple robbery. Because by intimidation, they tied the sister. And while the sister was tied, they were able to get the valuables inside the house. So two cases were filed. If you were the judge, would you convict them of said two cases? In this case, the Supreme Court said the crime committed is a complex crime under Article 48. It is a complex crime of robbery with violence against and intimidation of persons through robbery by force upon things. This is the case of People versus Francevilla. I'm saying this because this is the first time I heard this. Because usually, robbery with violence against or intimidation of person absorbs robbery by force upon things. Because robbery with violence against or intimidation of persons is always greater than that of robbery by force upon things because of the presence of violence and intimidation. So if both are present, usually, robbery by force 294 absorbs 299. But this time, Supreme Court said, it is a complex crime under Article 48. So the Supreme Court convicted the accused of robbery with violence against or intimidation of persons through robbery by force upon things. Why? Why did the Supreme Court complex it? The Supreme Court complex it because here, the robbery with violence against or intimidation of persons is only simple robbery. Robbery with intimidation. And therefore, it carries a lower penalty than that of robbery by force upon things. And so as to impose upon these offenders the greater penalty, you have to complex it. So the Supreme Court ruled that the crime committed is robbery with violence against or intimidation of persons through robbery by force upon things. There are two kinds of brigandage or two kinds of highway robbery. One is under Article 306 and the other one is under PD 532, the Anti-Highway Robbery Law of 1974. The following are the distinctions between brigandage or highway robbery under Article 306 versus brigandage or highway robbery under PD 532. First, under Article 306, the law requires that there must be at least 4 armed men. Whereas in case of brigandage under PD 532, the law doesn't require any number of men. Even one person can commit robbery in the Philippine highway. Second, In case of brigandage or highway robbery under Article 306, the mere act of forming a band of robbers will already give rise to the crime. Whereas in case of highway robbery under PD 532, there must be an actual commission of robbery in the highway for the crime to arise. Third distinction, in case of brigandage or highway robbery under Article 306, there is a particular predetermined preconceived victim. Whereas, in case of highway robbery under PD 532, there is no particular preconceived or predetermined victim. The offenders committed highway robbery indiscriminately against any person. And lastly, in case of brigandage or highway robbery under Article 306, any person who aids, abets, protects, or takes possession of the proceeds of the brigandage would be liable under Article 307, which is separate and distinct from 306. Whereas, in case of highway robbery under PD 532, any person who aids, abets, protects, or takes possession of the proceeds of brigandage would be liable as an accomplice. So those are the distinctions: brigandage under Article 306 versus brigandage under PD 532. A, B, C, D, and E learned that W will be buying a new car. So they knew that W would have money with him. And they knew that W would be buying in this particular store in Alabama, because they spotted him looking for a car at that store. And they overheard that he will be going there the following day. And so A, B, C, D, and E, who overheard the scene, went there the following day. And before W was able to go to the said place, A, B, C, D, and E, while W was still along the highway, A, B, C, D, and E, on board another car, cut the car of W. Thereafter, they alighted, and at knife point, they took the money that W brought along to buy the car. What crime has been committed by A, B, C, D, and E? Are they liable for brigandage under 306 or brigandage under PD 532? They are liable of brigandage under Article 306. The reason is that A, B, C, D, and E form a band of robbers in order to commit robbery in the highway against a particular person, W. They have a predetermined, preconceived particular victim in mind. Therefore, they are liable under Article 306. But what if A, B, C, D, and E, for months, had already been committing robbery along the highway? One time, they went again on the said highway, and they flagged down the first car that passed by, the first taxi that passed by, thinking that they were passengers at taxi stop, and they took the earnings of the said taxi driver at knife point. What crime is committed by A, B, C, D, and E? This time, they're liable for highway robbery under PD 532. They already formed this band, which is to commit highway robbery indiscriminately. No particular victim. And again, they committed it on the said taxi that passed by. Therefore, they're liable of highway robbery under PD 532. We go to theft. Theft is committed when the offender takes the personal property of another with intent to gain, without the consent of the owner thereof, without violence against or intimidation of persons, or without use of force upon thieves. So as I said earlier, both robbery and theft involves the act of taking, but in case of theft, there is no violence against or intimidation of persons, there is no force upon thieves. Under Article 308, however, there are other persons who are also liable for theft, aside from one who takes the personal property of another with intent to gain. The following are also liable for theft. Any person who, having found lost property, shall fail to deliver the same to the owner thereof or to the authorities. Likewise, punishes any person who, after having maliciously damaged the property of another, shall remove or make use of the fruits or object of the damage caused by him. And likewise, liable is any person who shall enter a field estate where trespass is forbidden or which belongs to another, and once inside, without the permission of the owner, she hunt or fish upon the same, or she gathers fruits, cereals, or any other forest farm or farm products. In all these instances, the offender becomes criminally liable for the crime of theft. The taxi driver, the tour of duty of this taxi driver is from 6 o'clock in the evening to 6 o'clock in the morning. So it is already 6 o'clock in the morning, time to go home. He went home, parked his taxi in the garage, and before entering the house, he cleaned first his taxi so that he could have a good sleep. And while cleaning the taxi, he noticed under the passenger's seat, he noticed a wallet. It seemed to have fallen from the bag of the passenger. And so he took the wallet, looked into it, and there he saw. It contains $1,000 and also 10,000 pesos. And he also there saw several credit cards. He also saw the ID, 2 IDs of the owner thereof with the address, the name, and other personal circumstances. Interested with the money, he kept the wallet and the money for himself. What crime is committed by the taxi driver? The taxi driver is liable for theft. But what if in the same problem, the taxi driver was an honest man? He wanted to return the wallet, but he was off duty tomorrow. He would not be driving his taxi tomorrow, and so what did he do? He went to the nearest police station in the area. And he surrendered the wallet to the said police officer at the front desk, telling him, I found this wallet at the passenger seat of my taxi. The owner is here, there is the ID, so I am surrendering this to you, Mr. Police Officer. And the police officer took the said wallet. There was receipt given to the taxi driver as evidence that the police officer received it. But the police officer, instead of returning it to the owner, became interested in the wallet and in the contents of the wallet. He did not return it. Is the police officer liable of any crime? The police officer is liable also of the crime of theft. The taxi driver is the finder in law. He is the one who actually found the wallet inside his taxi. When he gave it and entrusted it to the said police officer, transferred to the finder in fact. The accused, or X, was so mad at why he axed the bamboo fence in the house of Y. He axed each and every bamboo fence in the house of Y. It was, and then thereafter, he gathered this and brought it home, the pieces home. What crime or crimes have been committed by X? First, X is liable for malicious mischief, because he deliberately caused damage on the personal property of another. Under Article 327, the deliberate act of causing damage to the property of another outside arson is malicious mischief. So he commits malicious mischief. The moment he gathers the fruits and objects of this thing that he damaged, he becomes liable for theft under Article 308. Hence, he is also criminally liable for the crime of theft. If a person enters the premises of another, plantation of another, and gathered fruits without the consent of the owner, it is theft. The following circumstances will qualify theft. First, when theft is committed by a domestic servant. Second, when theft is committed with grave abuse of confidence. Third, when the property stolen is a motor vehicle, mail matter, or large cattle. Or when the thing stolen consists of coconuts from the premises of a plantation, or when the thing stolen is fish from the fish pond or fishery, or when the thing is taken on the occasion of a fire, earthquake, volcanic eruption, or any other similar calamity, or vehicular accident, or any civil disturbance. Any of these circumstances would qualify the crime of theft. If the offender who takes the personal property of another is the domestic servant, the domestic servant takes the personal property of the master, the crime committed is immediately theft. No need to prove grave abuse of confidence. The Supreme Court said, domestic servant is separated from grave abuse of confidence by the disjunctive word or. Therefore, they are separate and distinct from each other. Hence, the mere fact alone that the accused is proven to be the domestic servant, the crime committed is qualified theft. There is no need to prove the element of grave abuse of confidence. Grave abuse of confidence, as a qualifying circumstance for the crime of theft, the Supreme Court said in a number of cases, Sapanta versus People versus Tanchampo, Supreme Court said, the circumstance that will qualify theft is not merely abuse of confidence, but grave abuse of confidence. And there is grave abuse of confidence when there is a relationship of guardianship, dependency, and vigilance between the offender and the offended party. The domestic X is the helper in the house of this family of W, and X was a trusted servant inside. Because she was trusted, she has been there working for more than a year, so she was able to gain the trust of the owner of the house. And because of that, she was entrusted to get things from the vault, like cash, like jewelries. And one time, when the members of the said family were out, the said domestic helper connived with the security guard. Why was the security guard at the house? His obligation was to ensure the safety and protection of everything inside the house. But this guard, as well as the domestic servant, they have a relationship. They are boyfriend and girlfriend, and both of them conspired in order to take the valuables inside the house. The girlfriend servant saying that she knew where the valuables are. She knew the combination of the vault because she was trusted enough to take money and to get the jewelries. And so, the said guard entered the house. The servant allowed him to enter, and both of them, after the said servant opened the combination of the vault, both of them took the cash in the amount of more than $1 million, as well as jewelries. Thereafter, they used the same for their own personal benefit. The owner of the house learned about this, the act of taking by both the servant and the guard. What crimes may be filed against both of them? They can be held liable as conspirators for the crime of qualified theft. Both of them qualified theft. In so far as domestic servant is concerned, what qualifies theft is the fact that she is the domestic servant. In so far as the security guard is concerned, what qualifies theft is the act that the act of taking was done with grave abuse of confidence. The primary job of a security guard is to safeguard the protection and safety of the said members of the family and the house. The valuables inside. Yet he was the one who took the valuables inside. There was grave abuse of confidence because there was a relationship of guardianship, dependency, and vigilance between the security guard and the owner of the house. Therefore, they are both liable for qualified theft. But what if in the same problem, the said domestic servant connived with a friend? a good friend. They are both in need of money. And so the domestic servant advised the friend that she knew where to get the money. And so when the master and the members of the family were out, here comes the friend. The servant called her, and then thereafter, she allowed the friend to enter inside together. They took the money from the vault. What crime or crimes had been committed? By the servant and the friend. The servant will be liable for qualified theft, and this time, the said friend would be liable only for simple theft. The servant is liable for qualified theft because of the fact that she is a domestic servant. In so far as the friend is concerned, the said qualifying circumstance would not attach to her because it is personal to the said domestic servant. Therefore, in so far as the friend is concerned, it is simple theft. They can also be charged in the same information as conspirators. People of the Philippines versus the servant and the friend for qualified theft. But the judge will rule as follows, that the servant is liable for qualified theft and he will downgrade the crime insofar as the friend is concerned only to simple theft. X is the driver of Y, and Y has this very expensive car, the latest model of Mercedes-Benz. And X was the one driving. Y has to go to another country for 2 weeks. And so X was left. He is a stay-in driver. Now X has been courting Z. And he wanted to have a date with Z. And he told Z he will be fetching Z at the house. And so X did as he promised Z. He went to the house of Z and fetched Z using the Mercedes-Benz without asking permission from the owner, Y, who was in another country. Thereafter, he boarded Z inside his car, and they went, after dinner, they went around town, enjoying the use of this Mercedes-Benz. They went back home the following morning already. And thereafter, he returned the said car in the garage. But the moment the owner arrived, 2 weeks thereafter, he saw some scratches on the car. There was not even one scratch when he left. Now there were many scratches. And so it was then that he learned that this driver took the car for a joyride with a said girlfriend. He was so mad. And so because of that, he filed a case of qualified theft against the said driver. The owner contended there was intent to gain, even temporarily, because he took the said car and returned it the following morning. Therefore, it is already qualified theft, and there was great abuse of confidence. On the other hand, according as the argument of the driver, he is not liable for qualified theft according to the driver, because he has no intention to take this property as his own property. In fact, he returned it in the garage the following morning. If you were the judge, what crime has been committed by X? Would you convict X as charged? If you were the judge, you should not convict X of qualified theft. You should convict X of carnapping. The act of taking motor vehicle is no longer qualified theft according to the Supreme Court. It is already carnapping. The moment any motor vehicle is taken, it is no longer qualified theft. It is carnapping. Therefore, and they just have the same elements, almost the same elements. Therefore, the crime committed, although the crime charge is qualified theft, he has to be convicted of carnapping. Both carnapping and qualified theft involves the taking of personal property of another. And here, in case of carnapping, the taking of another's motor vehicle with intent to gain without the consent of the owner. Therefore, with or without violence against or intimidation of persons, with or without use of force upon others. Hence, do not convict, as a judge, you have to convict him not of qualified theft, but of the crime of carnapping. What about the contention of the accused that, according to him, he has no intention to make this car his own. In fact, he returned it. Therefore, it cannot be considered that he has the intent to gain. Supreme Court said that is wrong. Even temporarily, he has intent to gain because when he used the car, he has this enjoyment, pleasure, utility of the said car. And that is sufficient to show intent to gain on the part of the said offender. Therefore, crime committed is carnapping. If the property taken is large cattle, the crime committed is cattle rustling. Cattle rustling, however, although punished by special penal law, is malum in se, because cattle rustling is considered an amendment to Article 310. So if a large cattle, cows, carabaos, horse, ass, mules, or any other domesticated member of the bovine family, they are considered as large cattle. If they are taken, the crime committed is cattle rustling under PD 533. And if in the course of committing cattle rustling, the offender has killed or has inflicted physical injuries on the owner, the caretaker, or the overseer, the crime committed is only cattle rustling. The act of killing, the act of inflicting physical injuries would all be absorbed because cattle rustling is committed with or without violence against or intimidation of persons, or with or without force upon things. And if the said caretaker, the overseer, and the owner had been killed, it is within the meaning of violence involved in the act of taking the said large cattle. Hence, only one crime is committed, and that is violation of PD 533, cattle rustling. During a vehicular accident along SLEX, a bus hit and bumped a car. The said car turned upside down. The 5 people inside all died. Many of the passengers in the bus were injured. And these 5 people were brought out of the said car. They were there, lying on the highway. They were there, lying on the floor, on the pavement. The medics arrived and they were busy helping the passengers of the bus to get out of the bus and bringing the injured to the nearest hospital. Here comes W. W saw everything, saw everybody very busy. W took the bags of all the deceased persons. What crime has been committed by W? W is liable for qualified theft. The act of taking took place on the occasion of a vehicular accident. Therefore, the crime committed is qualified theft. W and his family had nowhere to stay. W and his family just live under the bridge. They went to this province, and thereafter, they were looking for a place to stay. They could not find any. They saw this big piece of land filled with tall grasses, and it was fenced by barbed wire. No one seemed to be guarding the place. So, they cut the barbed wire, they entered inside, took off the tall grasses, and started to build their nipa hut. This is now their new house, their new place. Here comes the guard. The guard entrusted to secure the place, saw W's family, and told W's family, "You are trespassing. You get out of this place. The owner of this place is in Manila. If you will not get out, I will report you to the owner." This angered W, and as a result, W hacked the guard. The guard died. Thereafter, W and his family proceeded with the building of their nipaha to serve as their house. What crime has been committed by W? W is liable for occupation of real property under Article 312. Under Article 312, the law punishes, first, taking possession of the real property of another by means of violence against or intimidation of persons, or usurping real rights and property of another by means of violence against or intimidation of persons. If what is taken by the offender is personal property, it is either theft or robbery. But if what is taken is real property, the crime committed is under Article 312, occupation of real property, usurpation of real rights in property. So here, W shall be charged for violation of Article 312. Even if W hacked and killed the guard, the said act of homicide, the said act of killing is simply absorbed in Article 312 because the said act of killing is within the meaning of the violence involved in order to commit the act of occupying another person's property. Let us add facts. After W and his family had built their nipaha to serve as their home, this incident that he killed the guard came to the knowledge of the owner. From Manila, where he stays, the owner hurriedly went to the province to visit his property, and there he saw for himself W and his family living already in his property in a nipaha. He went to W, and he confronted W, ordering W to leave this place. Otherwise, he threatened, I am going to file a case against you. This threat angered W, and W hacked the said owner of the house, owner of the property. What crime or crimes had been committed by W? First, he is liable for violation of Article 312. He occupied the said property of another by means of violence against or intimidation of persons, that is, by killing the guard. Therefore, for that, he is liable under Article 312. He is liable separate and distinct for the crime of murder, insofar as the owner of the property is concerned. The killing of the owner of the property shall constitute a separate and distinct charge, because it is no longer within the meaning of the violence involved in order to occupy the property. The property has already been occupied. The house was already built when the owner arrived. Therefore, such killing is already outside the violence which is necessary in order to occupy one's property. Hence, there will now be two cases to be filed against W. One is violation of Article 312, and the other one is murder for having killed the said owner of the property.